And we are very privileged to have with us David Faigman, who is Dean and Chancellor of the University of California Law College in San Francisco. And he will tell us all we need to know about advances in neuroscience-inspired law. David, the floor is yours.
All right, thank you. It's great to be with you. I'm going to take the privilege of actually changing things a little bit. I was on a MacArthur 2 networks on law and neuroscience, so I could probably spend a day just talking about all the interactions between law and neuroscience. But I've actually taken a little bit of a different approach to my keynote. And to quote Monty Python, and whenever you can have opportunity to quote Monty Python, you should. And now for something completely different. So I am a lawyer by training. I also went to graduate school in social psychology, so I have that as a background, which I guess gives me my bona fides for neuroscience. Historically, all technological revolutions, from the discovery of fire to roughly replicating and eventually superseding the human brain itself through AI, are innovations that interact with our brains. It is both simple and profound to say that we are our minds, and our minds exist, adapt, excel, and suffer in the world as it exists and the world that we make. Given that brains are at the center of it all, then it behooves us to consider how best to regulate influences on it. And that's really what my talk is about, is how do we regulate influences on kids' brains, but all brains. Historically, technical progress occurred on a human scale. The first movable type printing press was invented around 1000 AD, which was followed by Gutenberg's metal printing press more than 400 years later. And then it took several more decades before his press would spread across Europe. The first automobile was built around 1866, but mass production of automobiles did not begin until the early part of the 20th century with Henry Ford's invention of the assembly line. And even then, the growth of automobile traffic was fairly slow and gradual. The law similarly occurs on human scale, with rules of procedure, process, and adjudication that endure for years and sometimes decades. As long as technologies move at human scale, their regulation through judicial decisions, which is known as the common law, or legislation and administrative rulemaking, can be generally effective. However, this is no longer the case. Although the law continues to operate at human scale, modern technical advances operate at what might be termed quantum scale. And I use the concept of quantum scale advisedly and not to directly reference the actions of atomic and subatomic particles. Rather, I use it as a metaphor because it captures aspects of quantum physics that apply to technological advances, including, for example, the discreteness. Just as quantum systems have discrete, jump-like behaviors, technological innovations often feel like they make sudden leaps toward rather than gradual progress. Also, non-intuitiveness. Much as quantum mechanics defies classical intuition, like Schrodinger's cat being both alive and dead until observed, technological advancements can sometimes be surprising, disruptive, and incredibly hard to predict. And then finally, entanglement. In the same way quantum particles can become entangled and affect each other regardless of distance, our globally connected tech world shows how innovations in one part of the world can quickly influence and change systems in another. Increasingly, industry leaders in AI, but including some of the top names in AI, and they all signed a letter, but also extending to other converging technologies, especially including genetic engineering, robotics, and synthetic biology, have publicly lamented the potential apocalyptic consequences that might attend their inventions. While much has been written about what those consequences might look like, too little attention has been paid to fundamental processes of legal regulation and how they might adapt from their current human-scale timeline to both permit salutary uses of quantum-scale technologies and to avoid their potentially destructive proclivities. In short, AI is thought to be either the tool that leads to an epoch of human contentment or the end stage for all of humanity. The products of the industrial age fundamentally transformed societies in every imaginable corner. It led to the development of the assembly line and mass production of goods, raising living standards across most segments of society. Other consequences of industrialization reach far-flung areas of human endeavors, including the economics of capitalism and the political philosophy of Karl Marx. It also led to unimaginable levels of warfare, societal control through propaganda, and surveillance technologies. The technologies now on our horizon will make the last 400 years seem a gentle wave to the tsunami already on its way. And I'm attentive to using the word tsunami now in a somewhat different context. In my area of study, the law, industrialization meant evolving standards of regulation, including both the common law, that is the judge-made case law, and legislation, including the administrative rules that were the product of legislation. As a hardware technology of the 20th century built upon the industrial base, common law decisions and regulations adapted to those changes. The great steel and railroad mergers of the 19th century led to the passing of the Sherman Antitrust Act in 1890 and the Clayton Antitrust Act in 1914. Radio and television brought with them the FCC. The railroads, automobiles, and airplanes brought with them the FRA, the NHTSA, and the FAA, and so on. Because technological progress operated at human scale, it meant that both the common law and regulation could respond to changes in hardware and fit legal frameworks into settled societal expectations. For instance, the first automobiles were largely a product of late 19th century engineering and early 20th century manufacturing. It is instructive to ask, how did the law adapt to this changing technology when what came before it largely had four legs and was attached to a carriage? Instructive is a case, very famous in contract law, called McPherson versus Buick Motor Company, that was heard by the New York Court of Appeals in 1916, an opinion written by the great Justice Benjamin Cardozo. In that case, an automobile manufacturer, Buick, sold the car to a retail dealer. The retailer sold the car to a customer. So it started out manufacturer to retailer to customer. The retailer sold the car to the customer. McPherson, who was injured when a wheel made of defective wood, collapsed. The customer sued the manufacturer for negligence. From a legal standpoint at the time, the problem was that the customer bought the car from the retailer and was not in what is called privity of contract with the manufacturer. However, the customer was not, and because it was not in privity of contract, traditionally they could not sue from the customer back to the manufacturer. Cardozo wrote that the question presented is whether the defendant, Buick, owed a duty of care and vigilance to anyone but the immediate purchaser, that is the retailer. Cardozo found that the answer was yes. The Buick had purchased the wheel from another manufacturer and had no contractual relationship or privity with the customer, McPherson. It was still responsible for ensuring the safety of its product. Cardozo cited, in fact, an 1852 case, Thomas versus Winchester, in which a wholesaler sold a falsely labeled bottle of poison to a druggist who sold it to a local retailer who sold it to a patient. Though the written contract was between the wholesaler and the druggist, the court nonetheless found that the wholesaler was liable for the harm to the patient. The decision in McPherson marked a sea change in product liability law. What is important to notice, however, is that the common law evolved in this area over more than 60 years of product development. Technology no longer moves at this human scale. Yet the common law, and this is my main point, the common law and regulation continue to move at human scale. Consider several of the most obvious examples from the past couple of decades. In the case happening now, United States versus Google, the government is suing Google for antitrust violations using a law that is more than 100 years old for behavior that has been ongoing since 2010. Rideshare companies Lyft and Uber decimated the taxi business in a very short span of time, long before regulators or litigators knew what hit them. and Airbnb eviscerated local zoning laws, allowing entire residential neighborhoods to be transformed into commercial districts with multiple bed and breakfast businesses, although they don't typically actually have breakfast, just the beds. The pace of technological change no longer occurs at human scale. It operates as what I'm calling quantum scale. AI, synthetic biology, genetic engineering, robotics are together reducing the time scale for social impacts dramatically, a phenomenon that we can now only dimly fully appreciate. Moreover, advances in technology are largely decentralized. A couple of inventors working in a garage can turn the world upside down. It's the medical researcher in a small lab that can clone a human being. It's the hacker in a basement that can extort millions from public agencies. Even when the players are multi-billion-dollar companies, most of the innovations are decentralized. The question that I pose then is how can the law regulate technology that is decentralized and operating at quantum scale? Legislation and regulation are largely centralized legal processes, and litigation is decentralized but often operates in blunt force ways. I would suggest that there are many conventional possibilities, including, for example, administrative review of new technologies. Following the passage of the Sherman and Clayton Antitrust Acts, the United States created the Federal Trade Commission. The FTC provided the government with an agency that had the power to review mergers, investigate possible violations of antitrust legislation, and issue orders forbidding unfair competition practices. Federal and state governments are replete with agencies that have review and investigative and prosecutorial powers. The Food and Drug Administration is a particularly good example or salient example of that. And so the administrative agency solution is the question of whether technologies need to be reviewed up front before they are approved, just as we do with drugs and just as we do with suspect mergers. Another possibility is to turn to the courts. The courts, of course, have preliminary review power, whether it's a temporary restraining order or injunctions, and the courts might be better fact finders in real time even than administrative agencies, although I lean toward the first solution because administrative agencies have the power to create advisory committees. So the EPA, for example, the Environmental Protection Agency, has what are called scientific advisory committees where you have experts that are actually doing the reviewing, and then they make recommendations to the technocrats or the administrators. And then there is a final possibility, and these could be complementary to one another, and that would be to have some independent-styled review, possibly associated with an organization like the National Academies of Science. If you had, again, experts reviewing what's happening, that may be a positive way to do upfront evaluation before things take off too dramatically. The problem, of course, is that when you look at disruptive technologies, and the point I'm making here is that disruptive technologies, I know that term is a little bit old-fashioned, but disruptive technologies inevitably are disruptive to the regulatory frameworks of the technology that they are disrupting. And so the question is always going to be, how do you adapt new regulatory frameworks for these new technologies? And if you have something as powerful as AI, and we don't know all the different applications that it might be applied to, it becomes an ongoing, it's not both a preliminary challenge, but also an ongoing challenge as it's used in different contexts. So I'm not confident that any of these are up to the task, and maybe no legal processes can be imagined that would avoid at the front end the parade of horribles that could be imagined for the technologies coming online today and in the years ahead. I do think from the economic model, the question is, to what extent can you require companies that are, say, putting together AI that is going to be used by children so that they become depressed or they become hooked on something, to what extent you can force them to internalize the costs of the technology that they've created. And largely, the companies have really not internalized the costs that they basically impose on society, very often involving children. So we at UC Law are thinking about and working with Harris and Steve Carnevale and others to think about how we can bring lawyers together with technology partners and mental health partners and medical partners to start thinking about how the age-old functions of law and equity can be applied to these new fangled technologies that operate, as I say, at quantum speed. So I implore those that are thinking about the promise and the peril of these technologies to broaden their perspective and ponder the potential for systemic change in the way the law operates. Currently, the law is almost entirely reactive, and I think we should perhaps, as a society, decide the wisdom of opening Pandora's box before actually doing so. And I'm happy to take any questions if we have the time, and I thank you very much for your attention. Please, we might need a microphone.
Given that this is a global, there's AI happening elsewhere that comes in, and it's not necessarily one that you can, it's not a wheel on a Buick that's pretty local.
Mm-hmm.
Is this going to have to be a global legal solution? And is there, global courts have not been very effective because not everybody signs on to them,
Right.
like the United States.
Yeah.
But how do you manage things that are happening outside the borders that have a huge impact inside, like AI?
So I think it's a great question. I'm not sure I have a fantastic answer. I do think that on the sort of big ticket pervasive technologies, what we're seeing with privacy with the European Union has had impacts in the United States. The most recent iPhone is manufactured around European standards rather than American standards. So I do think that having international partners that are paying attention to this, even if the United States is taking a more laissez-faire approach to it, is a good thing in the United States. I think on the AI front, on the genetic engineering front, on the CRISPR and use of that, I think that's a lot more problematic. So you can have researchers in China or Korea, North Korea or South Korea or other places doing things that may or may not be entirely legal in their locality, but are problematic more generally. And then if you have folks that are traveling abroad to take advantage of those things, and we're going to see that. And the world that we're about to face is not just AI. It's AI merging, integrating with synthetic biology, merging with robotics, merging with these other technologies, and that's going to be the great challenge. But I do agree with you, and given the UN forum that we're in, I think an international approach is necessary. But given our history of international cooperation, and again, the problem is the decentralization of it. And so companies are really bad at internalizing, never really thought about. So when we used to teach lawyers, so that I create lawyers, that's my job. So sorry about that, but sorry, I know that's not necessarily a positive thing in everybody's view, right, synthetic biology. So we create lawyers. So it used to be that transactional attorneys, so attorneys that worked for Google and Microsoft and these great companies, their approach to the world was risk averse. And so when I talk to people at, say, gamers or, Lyft and Uber, so we know lots of people Lyft and Uber or Airbnb, they basically say, well, if we had lawyers there at the beginning, they would have told us we can't do that, because taxi cabs need, medallions, and Airbnb, there are zoning regulations, and so we can't do it. And so they did it notwithstanding. They broke it and then, and asked permission, after the fact or asked to be excused. And what you're seeing, but from the company's perspective, and this is from a shareholder's perspective as well, is, Google might get broken up, like AT&T got broken up. There are jurisdictions that don't allow Lyft and Uber to do business. And so they've been basically undermined on the backside. And so if you are an investor in these companies, you ought to take into account the possibility that, I remember when Zuckerberg was testifying before, I think it was a House committee, and he was basically asked, well, why don't you run your business without taking the personal information and advertising to all your users? And I was like, that is his business. He doesn't have a business other than stealing people's private information and selling it. And so if Congress had said, look, that business model is illegal, Facebook then would have folded. And so that's but that's why law is so slow, just like what they're doing with Google. We're 14 years past the actionable activity when it began in terms of the relationships with Microsoft. And that's what I think from a legal perspective, we need to take into account the realities of technological progress and ask how can the law respond to that technological progress. And I think I'm out of time.
Thank you so much.
All right. Well, thank you all. Thank you.